Good morning, everyone. Thank you for joining us. We will get started in the next minute. We're just going to allow a few more people to join the webinar. All right, welcome everyone. My name is Taya Brown and I'm the Administrative Coordinator here at the Temple Small Business Development Center. The Temple SBDC helps small businesses start, grow, and succeed. We do this through our no-cost consulting and a variety of our no-cost webinars and training programs like you're joining us today. You're joining us for legal formations. We are recording today's session. A copy of the recording and PowerPoint will be sent to all attendees within 2 to 3 business days in a follow-up email. All attendees have been muted. We encourage you to post any questions that you may have in the Q&A box. This program is a part of our Startup Essentials program. This program is designed to help you understand the basics of starting a business. Our regularly scheduled sessions will help you gain the skills you need to succeed and avoid mistakes. You'll receive more information about upcoming webinars in this program and our follow-up after this webinar. Now I'll turn over the floor to Tony Lopes.
Thank you very much. Welcome everyone to this webinar. This is a webinar that we do frequently with the SBDC, and we're always grateful for the opportunity to speak to all of you and hopefully help you to not only get the information that you need so that you can form the right entity for your business, but also make sure that you avoid mistakes along the way, okay? So as said, I'm Tony Lopes. I'm the managing partner at Lopes Law LLC. You can email us at info@lopeslawllc.com, or you can go to www.lopeslawllc.com for more information. We also frequently update our blog and post hopefully useful information to help you overcome some of the challenges that you may be facing in your business, and also to get the information that you need, hopefully, to help you out, okay? As I said, our firm does contracts, negotiations, business law, tax law. We do some estate planning, lots of intellectual property support. We also do some mergers and acquisitions activity, entertainment law, and lots of franchise law lately. So if you're interested or considering a franchise opportunity, make sure you reach out to us. We do free consultations. So we can speak to you regarding whatever you have going on and try to point you in the right direction. I'm also the founder and the host of the Self-Made Strategies podcast, which you can find out there. It's been quite a while since I've done a podcast episode for Self-Made Strategies, but there are about 150 some odd episodes out there to listen to with other entrepreneurs. So really good show if you can find it. If you can't find it, email me and I'll send you a link. I'm also the executive producer and director of a podcast called Believe in Progress, which is the American Association for Cancer Research Foundation's podcast, bringing cancer research information and hope to those affected by cancer. So please look for Believe in Progress on YouTube or wherever you listen to podcasts, and subscribe to that or share it with someone that may be going through their own cancer journey. You could help somebody out. And I'm an adjunct professor at Temple University's Fox School of Business. I teach entrepreneurial and innovative thinking, which is always a rewarding experience. Just a quick disclaimer before we dive into the webinar. This webinar is not providing you with legal advice. So it's intended for informational purposes only and not intended to be a substitute for professional legal advice, consultation, or advice. So Temple University, the SBDC, and Lopes Law make no warranties or representations as to this information. If you need legal advice, please contact us directly. As I said, we do free consultations. You can also reach me directly by emailing info@lopeslawllc.com, or you can call our law firm number 267-777-9117, and one of our lovely receptionists will redirect you to an attorney or to me, and we will try to reach out to you as soon as possible and try to help you out, okay? But again, not legal information or advice in this webinar. Please use common sense. This is not an instruction on how to DIY these things. As a matter of fact, you should hire an attorney to help you work through the formation of your entity. I highly recommend contacting a lawyer, even if it's not us, but again, you can always call us. The reasons for that are there are significant liability risks to forming an entity. And if you mess something up, it's going to be a lot more expensive to fix that down the line. There are tax issues and lots of legal formalities that are involved. I know we kind of live in this culture of start up for $0 or try to start an entity for as little money as possible. And I get that. I totally understand and empathize with the entrepreneurial drive and spirit that all of you have. But, forward thinking and getting appropriate counsel is a really good idea when you're trying to get your business up and running, because again, you can avoid a catastrophic disaster later that will be a lot more costly by spending some time and effort now when you're starting up your entity. For those of you who already have entities formed, we can certainly discuss what you may need to correct if you do. But we'll talk about that today as well. If you have any questions, just put them into the Q&A or the chat, and we'll try to address them as we go. We'll talk today a little bit about what the different types of entities are that you can form, and why you may want to consider forming an LLC or another type of entity. We'll also talk a little bit about the first documents that breathe life into your business, right? Because your business does become eventually its own entity, and we want to think of it as such, but that comes from this legal foundation, which is also associated with the documents that actually do that. We'll talk about the types of agreements that you need in the beginning of your business. So I'll make recommendations with respect to sort of the big picture of that first year of operations, the first 3 years of operations, and what best practices are from a paperwork perspective. And then we'll talk a little bit about why ignoring this advice will cost you way more than the fees associated with it now at the beginning. Okay, so again, feel free to ask any questions as we go. So first and foremost, why do you need to form an entity? As I said briefly, there are liability risks. So if you don't form an entity and you're just out there, operating as yourself without an LLC or an S corporation or something to that degree, you're completely exposed to personal liability. So if someone sues you, they can come after your personal assets. And even if you don't think you have a lot of personal assets and the risk is minimal, again, the stress of that liability, if you do get sued, is very high. And we do have clients at our firm that unfortunately, get sued by somebody, and having that entity offers an additional layer of liability protection that can be critical in those times of need. Additionally, and quite frankly, forming an entity is just a good formality to get you on the right path to treating your business seriously and with a level of formality that helps you to stay structured and organized, right? If you work with us, when we form your entity, we spend a good amount of time helping you to understand the best practices for operating that business in year 1, year 2, year 3, and so on. And hopefully helping you to really be successful and put yourself on the right path to avoiding a failed business, right? Which happens frequently. And most of the time, those failures happen because of lack of formality. And so, again, if we form an entity and you're doing all the right things, you're keeping your finances separate, you have a separate bank account, you're treating it as its own sort of entity and living, breathing thing, you're going to do a lot better, and you're going to have a higher likelihood of staying on the path to long-term success, okay? And then quite frankly, from a tax perspective, if you have an entity, you can benefit from lots of tax expenses that you can deduct from your income. Those things you may not be able to do to such a high degree if you're simply a self-employed individual who's operating under your name and not having a separate formal entity. Okay, so if you're a sole proprietor or even if you're in a partnership without another formal structure, you could be in a situation where you're just not benefiting from all of the tax advantages that you could take if you're an S corporation or an LLC, or in some instances, even a C Corp, although that's not one we typically recommend as much. Another thing is, quite frankly, you need to consider where your business is going to be and have its home state, right? Some people talk about forming an entity in Delaware. So, some of you may be from the Philly area or from New Jersey. Typically, we recommend avoiding that unless there's a particular tax reason for doing so. And simply saying, oh, well, I don't want to pay any, business taxes, so I'm going to form in Delaware, is actually probably not accurate. And in reality, you may still be required to pay taxes because just because you formed in Delaware, you're still operating in Philly, for example, and you're going to have to pay local and state taxes nonetheless. So a lot of times talking to us or speaking with an attorney that knows what they're talking about will help you make that decision in the right way for you, so that, again, you can be in the best position to avoid a mistake that you may regret later. And again, you need an attorney for this stuff, largely because we can help guide you through the process of what's the right type of entity structure for you, what's the right state to be in, and hopefully, that attorney is someone that can help guide you through that process in an empathetic way that understands your needs and goals, and help you make those decisions so that you avoid mistakes later on down the line. Again, this is not the time to DIY, right? I respect people's entrepreneurial spirit and wanting to do things themselves and save money, but you got to look at the big picture when it comes to a business and think long term, how is this going to affect, my ability to continue to be successful, continue to make money, avoid costly mistakes, avoid stressful and time-consuming mistakes, when I can just do things the right way now. And again, usually an attorney will help you to file the documents that you need to file, will help you to prepare any of the agreements that you need for your business early on, will help you to think through and look at the big picture of what that first year is going to be like, and look at those hurdles that you need to overcome and hopefully avoid some of those risks. Okay, so let's talk about different types of entities. I've already briefly mentioned the sole proprietorship and a partnership. So let's tackle those as quickly as possible. A sole proprietorship is simply someone who is an individual by themselves who start doing a business activity. So a lot of times you can think of this as someone who maybe is running an Etsy or an Etsy shop, or someone who's a crafts person, or someone who's baking goods in their house and then selling them to friends and referrals. That would be a sole proprietorship. So literally no filing requirement, nothing necessary for you to do. You just start engaging in some business activity as an individual. And again, the issue with a sole proprietorship is no liability protection, completely personally liable, totally exposed, and no real tax advantage. While you can expense certain things, you're not going to be able to maximize the tax savings of having a properly structured entity. The next level is what we would call a general partnership. And we won't get into limited partnerships because that's kind of old school, not seen as much today. There are still some limited partnerships, certainly, but we won't dive into that in the effort to avoid confusing people. If you're considering a limited partnership, I would say a corporation or an LLC is going to be a better structure for a lot of reasons, but let's focus on a general partnership. So a general partnership is simply a sole proprietorship times two or more. So if two people get together in business and say, hey, we're going to start baking goods in both of our houses, and we'll combine forces, develop an Instagram campaign and start selling our cupcakes together, right? That's two people instead of one. That's a partnership. Sometimes a general partnership can have a formal agreement, an actual partnership agreement. That does not typically change the liability structure. So merely having an agreement is not necessarily going to change your liability protection. So A general partnership is the same as a sole proprietorship in that instead of one person, you now have two or more engaging in this activity, but no liability protection. So both of those people are what's called jointly and severally liable for all of the liability risks of the partnership. Okay. So very, very dangerous to engage in a partnership or start operating in a business activity with someone else without sort of taking the next step in creating a corporation or an LLC. Now, corporations or LLCs, right? Both of these structures are going to have limited liability protection. So because you have a separate business entity, if that business entity gets sued, assuming you're not breaking any laws or defrauding anybody, that entity is going to get sued only to the limitation of what that entity actually owns. And so the personal property of the individuals who own the LLC or the corporation are typically going to be safe from any liability, okay, typically. The other question you may ask is, well, if I'm an individual, can I open an LLC or a corporation? The answer is, generally speaking, yes. So you can have a single member LLC, what's called the disregarded entity, and that's totally fine. Or we can have a corporation as well. There are ways to do that, okay? And so when you have a corporation or an LLC, the big thing that you want to be aware of is you're going to have a strong liability shield by having this separate entity. Now, the difference between C Corps and effectively everything else is that a C Corp is taxed, what you may have heard of double taxation, is taxed at the entity level. So they're taxed on their income as a corporation. And then when there are distributions, their shareholders or owners are taxed at that level as well. That's the double tax that you may have heard of. Now, S corporations and LLCs are what's called pass-through tax entities. And what that means is they're not taxed at the entity level, they're taxed passed through, just one tax passes through to the owners. So if you own an S Corp or an LLC, those are both pass-through tax entities. And generally speaking, those are the two entities that we're recommending to people, depending on what your particular business activity is, what your financial goals are, whether or not we can gain some significant tax advantages from going for an S corporation instead of an LLC, or if we'd prefer the simplicity of having an LLC over the slightly more complex S corporation, okay? And B Corps, just to touch on this, because this is something to consider, are certification of a business designation that balances purpose and profit. So let's say you have a business, and there are lots of these around. For example, United by Blue, if you want to look them up, is a clothing company in the Philly area, and they're a certified B corporation. And what that means is they exist beyond just the profit for some benefit. That's where the B comes from. And so they do something for some other grander purpose. And in the case of United by Blue, they donate parts of their profits and are involved in initiatives related to environmental impact, for example, but it can be for a variety of other issues. And that is something that you would apply for and become certified as to become a B corporation. If instead you're not going to be a corporation, you're thinking LLC, there's still an option to be what's called a multi-bottom line or triple bottom line entity, which is basically an entity that does a similar thing to a B corporation, where you exist for more than just your profit. You exist for additional bottom lines like a purpose or to support the planet or the environment. Some people choose to be more people-oriented as an additional bottom line. That's something to talk about with us or with another attorney if you're considering that, because it is a great way to structure a business and add some significant value proposition on the back end of these additional sort of bottom lines. But it's an important consideration to think through before you go through all of these hurdles. So again, just reach out if you're thinking about doing something that has a bigger purpose than just profits. We can certainly help. Now, which entity is right for you, right? You've got this sort of buffet of entity options. Which one should you fill your plate with? Well, it really does depend, unfortunately. As I said, there are tax considerations, there are liability considerations, there are certainly formality considerations. An LLC is going to be much less formal than, for example, an S corporation or a C corporation, which would be even more formal and have more tax obligations, right? So it depends. In talking to you, we can kind of help analyze your goals and empathetically guide you towards the entity structure that's going to be best for you. We could look at, hypothetical tax advantages. If your business isn't going to be doing a ton of revenue in the beginning, maybe we want to do something that's a little bit more cost effective and simpler and more efficient. But if it is going to be doing a lot of revenue, then we should be looking at, okay, well, what are we looking at? Cost of goods sold. What are we looking at? Big picture on your P&L, your profit and loss statement. And hypothetically, are there tax advantages that we can pick up on later by structuring our entity in a specific type of way? And if you're thinking exit strategy, which I know some of you are, right? The entrepreneurs in our community are always kind of thinking big picture. So if you're thinking exit strategy, we may want to think of what's easiest to transfer. Or if you're going to be doing seed rounds and looking for capital, well, what do we want to do from that perspective to make that easier for us down the line? So thinking about all of these different options and talking those things over with an experienced attorney or us, we can help to kind of guide you on that path of, well, which one has more pros and less cons for your particular situation. Do we have any questions? We'll take a quick break to see where we're at question wise.
Yes, we have a few questions. The first one is, what is a fair and reasonable cost, perhaps range based on services to use an attorney to set up a new business entity? Is it usually a flat rate fee or per hour rate? If per hour, what is the hourly range?
Okay, that's a great question and a loaded one, obviously, right? The only thing I can say is that generally speaking, you want to work with the attorney that's, of course, transparently going to be the best for you from a cost perspective. Affordability is a major issue. But the best advice I could give you, and we're going to cover this again, so I'm probably going to beat this horse a little bit, but the best advice I could give you is you want to work with a lawyer that speaks your language, that you feel good about when you speak to them, that doesn't talk down to you, that can speak in plain English to you, that culturally is a good fit for you as well. Somebody that you want to be engaged with, right? That you want to be able to call and rely upon when you need them, because that's going to be worth their weight in gold long term. What's a good hourly rate, or what is the appropriate structure? Firm by firm, that's going to change. So as I said, you want to contact them, get a feel for them if you like them, and just make sure that they're a good fit, and get the pricing transparent up front. Whether that's a flat fee or an hourly rate, that's up to them to decide, but you need to ask for transparent pricing for something like this, which should be relatively transparent. We do flat fees at Lopes Law. You can call us because it does vary based on the size of the organization, the number of founders, et cetera. And that's something that we would certainly discuss on an initial consultation with a client, looking at your business, looking at tax structure, looking at the different type of entity that might be a good fit for you, is going to change all of those things. But again, you want transparent pricing. What we see a lot of out there right now is a little bit of maybe what we would call bait and switch in the legal community, where a lawyer might, lowball you to get your business, but then big picture is there are hidden costs and fees. So if you are getting a flat fee, ask, what does that flat fee cover? Is it all inclusive? Is it limited by an amount of time? Is this going to be in the engagement letter that the lawyer is going to send to you? Ask those questions. Don't be afraid. And as a matter of fact, if you're asking those questions and they're butting up against you and the lawyer isn't answering those questions transparently, and you feel a sense of apprehension, that's a sign that that's not going to be a good relationship for you, right? So pick the lawyer that makes you feel good, that speaks your language, that's empathetic to you, and that's somebody that you would want to call when you need them. Okay.
The next question is, does the Commonwealth of PA require an annual tax return for LLCs?
Well, it's filed. So again, it's a pass-through entity, but yes, you are expected to file what's called an informational return on your tax returns. So that would be a Schedule C at the IRS level, and then state by state, yes, you are going to have to file a return and pay taxes on that income state by state. And typically every state is going to be different. Certainly Pennsylvania has that requirement. Again, that would be something more so for your accountant to help you with than an attorney, but yes.
The next question is, I thought the LLC tax filing is through a PA form or a CT 101, or is it perhaps other forms?
Again, tax form questions are going to be more accounting related than something that we're going to cover on this webinar.
Can you transition in and out of entity types over the course of the business?
So the general answer is yes, but with a major asterisk, in the sense that it depends on the type of entity that you're in and the type of entity that you're trying to convert to. Yes, it's possible, but can be costly, can be complex. There are state filings, there are registration issues there. There's, contracts that need to be changed and drafted most likely. So again, proper planning, really thinking through your business structure, proper budgeting, thinking about how you're going to generate revenue, where you're going to head with this business is important as early as possible. You don't want to be changing things up over and over and over, right? So there are a variety of different ways to handle that scenario. Sometimes, for example, if you're an LLC, you can elect to be taxed as an S corporation. There are filing requirements, there are forms that need to be filled out, there are registration requirements that go along with that. So there are ways to modify the tax structure even without changing the entity structure. So it depends heavily on why we're doing that, but I would say that's not something that you want to be doing frequently. Hopefully, fingers crossed, you've properly set up the entity and you're structured in a way that puts you in the best position long-term for your business without needing to change that. If there's a reason to change that, then that's an important discussion to have with an attorney. Again, call us or call another attorney, because there are a lot of complex steps depending on what you're trying to do.
The next question is, would you recommend LegalZoom for advice?
Absolutely not. So I would say that working with a live attorney is very different than these sort of aggregator services. And so, no offense to them, great, they developed that model. But I think that, relying on a service like that, typically when we see them, it's, agreements that are not up to snuff. It's bad advice. Frankly, again, I can't say this enough. Generally speaking, attorneys are worth what you pay for them. So the cheapest option is not going to be the best option most of the time, right? Logically speaking, the cheapest attorney is not the cheapest because they're the best. So I'm not saying you should be paying, top dollar huge firm for a formation or a simple entity question. But again, I think it's more important to focus on budget's certainly important, but you got to look at the bigger picture of working with a lawyer that's really going to empathetically care about helping you through this situation, whatever your situation is. So I do not recommend LegalZoom, don't recommend Rocket Lawyer, don't recommend any of those services, not pointing any fingers at them specifically for any reason, but let's face it, you're paying a service that's aggregating to a lawyer and there's a disconnection there. And I don't think that you're getting the best quality service if you do that personally. So that's my opinion.
If an LLC is structured as an S Corp for tax purposes, does this LLC have shareholders like an S Corp does? does or doesn't need officers?
So an LLC has members, which are basically like shareholders, but not exactly. So, and an LLC has a bit more flexibility in terms of how we handle profits and losses, how we handle membership interest, meaning the ownership percentage of each member. You can also have what's called units, which is basically like shares. Basically, don't hold me to that in full detail, but effectively they work kind of like shares rather than a percentage interest. So we can have units, we can have preferred units, we can have common units, we can have multiple classes of units in an LLC. You can do all of those structural things in an LLC. Typically, it's not a requirement that you have a board in an LLC. Our board's a best practice in terms of corporate governance or entity governance, if you want to use that terminology instead. Maybe it depends on your scenario, right? But the LLC is going to have a lot of flexibility in terms of what we put into the operating agreement and sort of the risks and obligations of the members / owners. And so they're not shareholders. That's more of a term of art for corporations, but in an LLC, you'll see that the members are the owners, and you can divvy that up by percentage. You can divvy that up by units. We can play with those things and change things around.
Okay, we have about 10 more questions. Did you want to continue?
Yeah, let's take a little break from the questions and then we'll come back to them. I promise we'll try to cover all the questions in this webinar, but want to make sure we get this information out there. So, okay, we've got our entity choice. We've decided what we're going to do. What are the literally first set of documents that we need to breathe life into these entities, right? So if we're talking about an LLC, generally speaking, we're talking about what's called an operating agreement. The operating agreement is a document that we put together that lays out all of that terminology and the risks and obligations and what everybody's going to be doing and what everyone's going to be entitled to with respect to this limited liability company. Now, if you're a single member LLC, I still strongly recommend an operating agreement that is a little bit more future-proofed in case you decide to sell some of your interest or bring somebody in, and so that we have these discussions about how to structure this business going forward, right? Because the operating agreement is effectively, in an LLC, the agreement between the entity that, okay, it's, figuratively exists, and the owner. And even if it's a single member LLC, it's sort of the agreement of how that's going to operate. In a single member LLC, it doesn't need to be overly complicated, but we can certainly make sure that we cover at least some of these things that you should be thinking about big picture in terms of how to own and operate this business. Now, if you have two or more individuals in an LLC, that operating agreement is effectively going to be operating as the agreement between the members, with the entity, but between the members. And so that's our opportunity to talk about profit sharing, loss allocations, who's going to be doing what responsibilities and accountability exists among the members, again, AKA the owners, and how does that work? And worst case scenario, what happens in the event of a voluntary or involuntary exit from the LLC? Okay, and a voluntary exit would be, I want to sell, or I want to transfer, or I want to leave this to my family in my estate planning documents. Those can be voluntary exits, right? So we might put in some buy-sell provisions. We might put in some rights of first refusal for the other members. We might put in some like tag-along rights, things like that, okay? Involuntary would be things like, well, what if one of the members goes bankrupt, goes insolvent, or has a creditor that's coming after them? Can they get access to their LLC ownership interests? We don't want that, right? The other members aren't going to want that. Can they, what happens if they want to retire? What happens if they want to leave? Or what happens if they predecease the other members? What happens if, again, something happens to that ownership interest that is involuntary? How do we affect those situations? Again, a good operating agreement is going to have those things in it. So that's really the key issue with potentially using organizations online. Again, LegalZoom, Rocket Lawyer, not necessarily pointing the fingers at them, but those organizations can be dangerous if you're not getting this level of detail. And so generally speaking, working with a good attorney that you're working with directly, you can get answers to these questions and you can think about these things preemptively to avoid problems. We can also address things in a multi-member operating agreement like, well, what if one of the members just stops doing what they're supposed to be doing, right? Let's say you've got 4 or 5 members, owners of this business, and one of them just, they were there in the beginning, but all of a sudden they're not showing up. They're not, putting their blood, sweat, and tears into this business like the others are. What do we do then? And we can address a lot of those issues in that early document, setting the tone for how this organization is going to be run, but also how we're going to handle the hard times, how we're going to handle disputes, how we're going to handle scenarios where we're stuck, right? And so we've had clients that have been in these situations where they're kind of stuck and they're handcuffed to this other person, and if they don't have a strong, favorable, even-keeled document like an operating agreement that was appropriately drafted, they're handcuffed to this individual, and that can make it really difficult. That can cause burnout, that can cause a lot of stress, that can cause a lack of ambition to want to see this business that could otherwise be profitable carry forward because someone isn't carrying their weight with respect to the business. In an S corporation or a C corp, we would have shareholders agreement and bylaws. Now, the bylaws are generally speaking for how the board of those organizations are going to be run. We're not going to get into the nuances of board of directors and how that operates and all of those things in this particular webinar. But if you're considering a corporation and you want to set up a board of directors, we would need some bylaws, and we could discuss those things again with you, how that's going to structurally work and the formalities of those things. The shareholders agreement is kind of sort of like the operating agreement, right? It covers the agreement among the shareholders, among the owners. And again, similar issues are going to be covered in that shareholders agreement. What happens if somebody wants to leave, if they want to sell their shares? Is there a right of first refusal to the other shareholders? And generally speaking, we want to see those things. And even in an estate planning perspective, right, if one of these shareholders or one of the members in an LLC predeceases the others, there are lots of estate planning issues that can be curbed by strong agreements, meaning we can address those things preemptively. And if somebody predeceases the other, the company doesn't fall apart, right? It can keep moving forward, still providing an economic benefit for the estate, but without losing control to this potential phantom owner. Okay. All right. Again, contact an attorney if you have questions. Hopefully I didn't scare any of you too much, except to say that these are very complex documents that have a lot of moving pieces, and a knowledgeable attorney can really be worth their weight in gold in helping you to overcome these challenges before they even happen, hopefully. Okay. The other thing you'll need is an EIN, an employer identification number. Now, generally speaking, you can think of this as your business's social security number. It's the identifying tax ID with the IRS for the business. That's needed in an LLC, that's needed in an S corporation, that's needed in the C corporation. And that would be a best practice as an initial first step. And then once you have all of those things, you go to the bank and pick the bank of your choice and open a bank account with those items, with an EIN, with the operating agreement or shareholders agreement. Okay. Then once you have your business bank account set up, you would then use that bank account for all of the business's finances, collecting all of that revenue, paying for any expenses, including hopefully payroll and distributions to yourself as the owner from that business. Okay. All right. So what information do you really need to gather before, hopefully, you go talk to your attorney to get this stuff set up? Okay, first and foremost, if you're going to set up an entity, you probably want to have at least 3 names. With respect to tips for naming your business, I would typically recommend that you think big picture, right? And so common terms are not going to be as trademarkable, okay, not as protectable from an IP perspective as nuanced, arbitrary terms, things that don't exist. So if you make up a word for your business, that's going to be, generally speaking, a best practice. And that's going to be better than Tony's Pizza, because Tony's Pizza, as we know, there are infinite amounts of Tony's Pizzas out there, or Joe's Coffees, or whatever, right? And so those are not going to be protectable if I'm trying to create a brand that I want to see, kind of blow up and be scalable from an IP perspective, from an intellectual property perspective. So from a naming perspective, different philosophies are going to think of this differently. Tina's Construction LLC is not a great name from a trademarking perspective, but what's in a brand is what we would say, right? You would pick, you would create that brand, and then that brand evolves from the business activity and the branding that's applied to it, not the other way around. Clever names like, best coffee or greatest nails or whatever, right, are not going to be great from a trademarking perspective either. So I want you to think that, the cleverness in a name can be an effective marketing tool, but might not have the IP outcomes, the intellectual property outcomes, the trademark protections that you're looking for. Again, working with a lawyer can help you overcome those mistakes early on, right? So working with us, for example, we would help you think through that. If you're struggling to come up with a name, I would say that better than Tony's Pizza would be TL's Pizza, right? So Tony Lopes Pizza. But that has a little bit more, okay, it's not as on the nose. It's a little bit more protectable, not totally protectable, but a little bit better. We're getting closer to where we want to be. And we can do things like that, okay? Again, trademarking discussions, intellectual property discussions are things to really be discussed with a lawyer that has experience in that space. We're happy to have those discussions with you as well if you give us a call, okay? Another question to ask yourself is, how much startup cash will I need, right? And I will tell you that if your answer is $0, that is not a good start. Unfortunately, we've developed this culture largely on social media, and because of kind of misinformation that's out there, that you can start a business for $0. Frankly, I don't think that's accurate. You need money for a website. You need money for, even to set up your Google Suite or your email. You may need money for a separate phone line. You may need money for legal, for accounting, for, other startup costs. I would say it depends on the business, but you should sit down and theoretically work through a hypothetical budget, right? Where am I going to get my clients? Where am I going to generate revenue? How much is that going to cost me to do? Do I have, Google ads that I'm going to need to spend money on, or Amazon ads, or Etsy, or whatever that cost structure looks like? Realistically, what is the nice to have big number? What's the absolute minimum number? And where do I go in between? And then the biggest thing that I think that a lot of people don't think about, and that should be talked about as early as possible, is, what's my break even, hypothetically, right? I'm going to spend X. When do I expect to make that back so that I'm breaking even on my initial expenses to start this business? If you're starting with the absolute minimum, it's not impossible, but you really need to be very organized to put yourself in the position to not get into trouble, right? So how are we going to finance this? What are the minimums that I need? And what does that look like? I would say if you're sitting here and you're thinking to yourself, I have no idea how much I need, I don't know where to start from a budgeting perspective, I would say an absolute minimum would be somewhere in the ballpark of several $1,000s to be able to cover, again, website fees, right? Whether that's Wix or another service, legal fees, regardless of what channel you're using to cover that, perhaps some accounting fees, because you are going to have to file taxes. You may want to have that set aside, and then thinking about those pieces. Now, the other thing is, rather than thinking of starting a business with $0, I would rather see you be as savvy as possible in saying, okay, this is the budget I can afford. Let me go out there and try to find the best that I can get for that scenario. Or, call people up and say, hey, I'm going to need a lawyer. How much would it cost to do X, Y, and Z from your firm, right? And again, looking for the right balance of fits within my budget, but I really like this professional because they're going to be a great value add to my business long term. Another question to ask are you going to need employees? And if so, how many will we need in our first year of operations? I will tell you from experience, solo lawyer for a long, long time, have done other entrepreneurial endeavors throughout my life on my own and with others. Working with others is a lot better than working by yourself. So if you're going to be realistic about starting your business and you're saying it's just going to be me, I'm going to do everything, that's going to be a much harder path than, having either employees or collaborators who are going to be partners. So next question is, if not employees, then maybe I'm going to work with some co-founders and I'm going to combine forces, or I'm going to be solo and be independent, but find other independents that work in tangential services or products to mine, and we can work together and share our efforts and resources in that way, right? If we're going to do that, either of those two, employees or some level of partnership or collaboration, again, thinking through that relationship and really being forward thinking is going to save you a lot of stress and money in the long run. So think about, am I going to have employees or partners or collaborators? If so, how many in that first year? What's, my big picture? What's realistic? How do I course correct if I'm not on that right path, right? If I say I want to have 3 employees in the first year and frankly, things don't work out the way I intended them and I only get 1, how do we deal with that, right? And sort of having a plan B is a good idea. But also thinking through the structure of these relationships between you and your employees, you and your prospective partners and collaborators, and being as transparent as possible, hopefully guided by an attorney, but if not, as transparent as possible so that you can protect your mental health and your stress levels, but also the kind of core of this business that you're trying to get off the ground will be a real big value add long term. And if you're bringing in employees or partners, we'll probably touch on this a little bit later as well, but you're going to want to have agreements with those individuals, right? Who's supposed to do what and when? What are the accountability things? If they don't do what they say they're going to do, what's going to happen? How do we terminate that relationship if necessary? How do we avoid, long-term liability? That's sort of the overarching 30,000-foot view theme of this presentation is avoid liability at all costs. Okay. So despite being an attorney, I hate litigation. I don't want to see any of you end up in litigation. And so to do that, be proactive in your sort of pre-planning at every phase. That will help you avoid that dreaded L word, litigation, long-term. Okay. Litigation is costly. It's stressful. It's time consuming. And quite frankly, you don't want to get in front of a judge and be rolling the dice on what the outcome might be. Okay. You want to have a lot of control over what is happening, control your own destiny here by doing all of these best practices. That's the goal. Okay. Last but not least is, what state are you going to form in? I touched on this earlier. Typically, not always, every case is different, but typically you may just want to form in your home state, work through the taxes if you want to and kind of figure it out. But that's generally speaking going to be the simplest and the most straightforward. Is if you live in Philly or if you live in the surrounding suburbs, form in Pennsylvania. If you live in New Jersey, form in New Jersey. If you live in Delaware, form in Delaware. Forming in Delaware, Nevada, Wyoming, because of this zero tax in quotes, is not the greatest strategy because you're going to have administrative burden. You're probably going to have additional fees. You're going to need to have a registered agent in that separate state. You're going to need to stay on top of that registered agent service. We've seen clients come to our firm saying, I formed in Nevada because I thought I was going to pay zero taxes. And now all of a sudden I'm getting hit with, a state fine because I haven't met my requirements in that state. Or my registered agent is dropping the ball and they're not sending me my things that I'm receiving in the mail, and I missed a tax notice or I missed something that I was supposed to have. Those are risks that can be avoided, right? Now, if you have a big business on your hands, manufacturing or something that a SaaS product that's going to generate a lot of revenue, and you want to pick one of these states and you're actually going to properly structure and set that up, great. That's a conversation to have with your attorney and your accountant and try to figure out if this makes sense, big picture. Okay, so again, it depends. If you're asking me generally and you're asking me, which state should I form in, and I had to put a blindfold on and just pick one, I would generally say, pick your home state. Okay, because that's going to be simplest and again, less stress long term. All right, before we dive into the agreements, let's hit some questions if we can.
Okay, we have a few questions. What is the main difference between an LLC for an entity and single member LLC? Is it easy to go between the two as the company grows?
Yeah, so the difference is merely in the number of members, right? So a single member LLC is single member, one member, and then a multi-member LLC is two or more. And so to go from single member to multi-member is a matter of effectively selling some membership interest or transferring some membership interest, right? So if you're a single member, that means you own 100% of that LLC or 100% of the units of that LLC if it's structured that way. And then if you're going to bring in another member and they're going to buy into your business, they would be effectively buying a percentage ownership interest in that business. That's effectively how that would work. So there is a transfer process there. There is a formality to transferring ownership interest in an LLC. And there are some tax ramifications depending on how that's structured and how that transaction occurs. But that's something you want to discuss in more detail when that time comes with an attorney.
The next question would be, if we engage or want to work with an attorney, should there be some sort of documents to sign that execute both parties that define the services and costs?
Yeah, so typically an attorney is going to have an engagement letter that they would provide you with, typically. And, again, transparency is key there, right? So you want to work with an attorney that's being transparent about how you're going to get billed and what your fee structure is going to look like. Different scenarios are going to change things. We do some flat fee work, we do some hourly work. It really depends on each specific scenario.
What happens when you form an estate, but it's not where you see yourself settling down in the next 2 years? Is the transfer to another state necessary or easy?
I would say that you want to consider that, right? Again, because of the administrative burden of being in a separate state than you're physically residing in or domiciled in, because there's just going to be some administrative disconnect there and some management that's going to be additional and maybe not as necessary. I would say that the process state by state is different, and it can be switched, but it's probably going to require some registration and some filing fees and some legal work.
Which is better, a multi-member LLC or partnership if the business has 3 individual owners?
Well, again, if we're just talking about a general partnership, and that's a very specific legally defined term, then the liability risk is greater than an LLC. We would generally recommend that there be an LLC formed to encapsulate that partnership rather than just having a regular general partnership that's exposed to the liability risks.
Within an LLC, do you always file your taxes with personal taxes?
An LLC is a pass-through tax entity. So generally speaking, it would be a Schedule C on your return. Again, those are questions for your accountant more than anything else.
Can an accountant form an entity, or is it best to use an attorney to do this?
My favorite question. So I have some opinions when it comes to accountants filing entities for clients. So it is something that accountants do. Look, if you came to me, I'm a tax attorney. I have my master's in tax law. I would never file a business tax return for a client. I would refer them to an accountant. I personally think that no accountant should be filing entities for clients, that they should be referring that work to an attorney. The reason for that is an accountant cannot draft an operating agreement or shareholders agreement or bylaws for you, and they can't give you legal advice. And so those accountants who are out there doing that, they're doing so at their own risk. Most of the time when clients come to us and they say their accountant's going to file it for them because they're cheaper, you pay for what you get. And so I largely think that it is not a best practice. I think that it's something that should not be done. And I caution you to be careful about accountants that are doing that kind of practice. Again, it would be the same thing as you going to a lawyer that says they're going to file your income taxes for you. Probably not a good idea.
Should you come to an appointment with a lawyer like you have prepared to have this conversation, what documents should be ready to answer?
Yeah, I mean, generally speaking, that slide, and we'll go back to it real quick, where we covered the necessary information to gather, right? This is some of the stuff you want to think about probably before that initial meeting so that you can get the most out of it. But your lawyer should kind of guide you on these things that you need to gather for that meeting. And so, we try to do that as much as we possibly can for our clients. We try to help them think through those things. We try to get them the necessary, questions step by step to kind of guide them through this process. And so, it's great if you have this information. It's great if you're collecting, a lot of the necessary things that you should be thinking about anyways. It's just a good best practice to work through some of these things. But is it absolutely necessary? It's not going to affect that meeting as much, but you might not get as much from the meeting if you're not prepared. So being prepared would be best practice.
We have 3 more questions. The first one is, what do you use for a business address when you're fully remote and don't want to use your personal address?
Well, so there are a few different recommendations here, right? A shared co-working space is a great idea. We use them. Our law firm uses them. We're largely remote law firm, and we use shared co-working spaces for those purposes. It's also not a bad idea if you're a full remote individual to have a shared co-working space to rely on to just, if you need it, to get out and meet people and network and, good for business overall. So I would recommend looking for a shared co-working space. There are some really great ones here in Philly. I can't speak highly enough about Indy Hall. They're a big collaborator of ours, and they're one of the shared co-working spaces that we use. Of course, choose your own co-working space, but Alex over at Indy Hall is just an awesome individual and connector, and Indy Hall is a great staple in our city. So if you're in Philly, check out Indy Hall. Tell them we sent you, and they'll take good care of you. But then again, pick the right one that works for you. Other than that, generally speaking, you can get a UPS box, you can get a PO box, you can get other things to kind of cover that. I would not recommend using your home address. You cannot use a PO box or a UPS box to register your business. So just to be clear, that is not, generally speaking, not best practice. So you do need some address to use as a registered address for your business. And there are also registered agent services out there that you can use that kind of stand in. We touched on those briefly as well. But if you find a good shared co-working space that has a mail receiving option, that's probably going to be a good option for you. I would recommend not using your home address typically, but because these documents are, your state registration is going to be public record. So
I have a sole proprietorship which has been dormant for years in Philadelphia that has been used for rental business. Can I file to switch the entity from sole proprietorship to LLC?
yeah, so we can create an LLC. If you own real estate property, there may be a transfer tax issue there that needs to be discussed again with an attorney, and maybe with bringing your accountant into that conversation, maybe, because you may have some transfer tax issues. You can also sometimes use a trust as a different form of entity. So that might, if you're looking at sort of big picture estate planning, a trust might be a good option instead of an LLC or a corporation. And that might offer some similar liability protection. But yes, is it possible? Yes. Are there costs involved? There may be. So something to consider.
And then we'll take this next question and then proceed. I own a property which my business is on. Do you find it to be the best practice to set up two LLCs? One which the property and physical assets, one which owns the property and physical assets, and another LLC which is the business?
That's a great question. It is very dependent on your specific circumstances. So I will say, classic lawyer answer, it depends. Generally speaking, it's going to come down to, is there really a separation of, the finances and stuff, or is this property just something that's literally only used for this one business? And therefore, if it's owned under the LLC, it's not really changing anything. And the reason I say that is, if you're looking for liability protection, which is what it sounds like you might be looking at, if someone slips and falls on your property or something like that, generally speaking, if you're getting sued, you're going to be in a scenario where the plaintiff is probably going to be trying to come after as many of your assets as they can. And so if it's used for the same business activity, I'm not sure that you would get any additional actual liability protection just from merely having two separate LLCs. And that's a common misconception that exists out there, that, if I just put every single property under different LLCs, I'll be protected. That's not 100% true. It really does depend a lot on the circumstances, as most things do. And so you would really need to kind of take a magnifying glass and look at the nitty-gritty details of your specific situation and think through the overarching liability protection. So maybe yes, maybe no. It would really depend on your specific set of circumstances. Okay. All right. So let's continue. So now you've got your business set up. What's next, right? What are the immediate next few steps that you need to take? Well, aside from really thinking about, the big picture of your target audience, your clients that you're going to be looking for, customers, clients, whatever individual we're going to service with products or services, we probably want to start thinking about how we generate that revenue, right? So first and foremost, what's our value proposition to those prospective clients or customers? What are they coming to us for? What differentiates us from our competition? And then within that sort of sphere of thinking, how does that move down the pipeline for us, right? And at the end of that pipeline, if we're delivering services to our clients, then we probably want a master services agreement. And we say master agreement because if you came to us, for example, we're going to talk to you about your business. We're going to try to figure out, what that, closing the client looks like. and work through hopefully template or master agreement custom made for your business to handle that closing procedure. And so we're going to create an agreement that protects your business interest, lays out the terms of the services that are to be delivered to your client, but builds that relationship, helps you to generate that revenue while being protected. Now, if you're selling a product, it really is going to depend on what that looks like, and whether or not you need an agreement in tandem with that product, that deliverable that you're delivering to your client. Different verticals, different businesses, different areas are going to have different requirements, but you probably want some kind of customer relationship management agreement in place. Again, if you're selling a straightforward product, maybe you don't need that. So, but for a lot of services businesses, you want to have some level of an agreement as part of your closing process, right? So master services agreements, certainly a consideration. If we're hiring employees or subcontractors, even 1099s, first and foremost, do not make the mistake of just assuming that you can hire subcontractors to save yourself money on taxes. That's also a misconception. And make sure you're working with an attorney that really thoroughly understands what those relationships are looking like and can guide you through whether they're going to be W-2 employee or 1099 subcontractor. You don't make that decision. It's a tax designation. So we need to look at the relationship and figure out what's the right structure for that. If we can 1099 them and that's what you want to do, then what does that look like and how do we do that correctly? Not just we're going to call them 1099s because we don't like paying taxes. That's not necessarily the way it works. So again, if you're hiring employees or subcontractors, A, you need an agreement in place, need to have one, and B, talk to an attorney that understands those relationships at a very high level, that understands at least at a high level the tax principles involved, and helps you to make the right decision for your business. You do not want to get hefty tax bills. That is a big time, a big problem that can be avoided by proper pre-planning. So avoid, tax penalties and interest can really hurt if you're not doing the right thing. So make sure we're careful about that. Then next is, are we going to be engaging with vendors? Most likely, right? Now, look, if you're, getting a SaaS product like Google Suite, Gmail, et cetera, for your business, do you need a lawyer to review those vendor agreements? No. Do you, because there's not going to be any negotiation, there's not going to be anything that really is going to affect a large percentage of businesses out there. So not saying that. What I am saying is if you're working with a local vendor that's going to be involved in the distribution of your products or help you to deliver the services to your clients, well, then we need to have structured vendor agreements. We need to make sure that those vendor agreements are a good fit for your business. Again, talk to an attorney, whether you're drafting them from scratch or whether you're reviewing your vendor agreement to make sure you understand it. Attorney is worth their weight in gold in that scenario. IP considerations are intellectual property considerations. Trust me, every business has intellectual property. So you should have some notion of what that intellectual property is and what, if anything, are you doing to protect it. We offer, at our firm, startup packages that help do audits or discussions, or you can always just, meet with us for a half an hour on the clock or an hour on the clock to work through some of these issues so that you understand them. Intellectual property is a major concern. If you have a client list, that's a trade secret, technically. And most people don't think of that as intellectual property, but it is. It's something that you've worked hard to develop, right? Your processes, your systems that you've set up and have in place, those are intellectual property. They're your trade secrets. So what are we doing to protect them from, our competitors or from other prospectively dangerous scenarios, if anything? Super small business, something that maybe is not quite at that level. Maybe you don't need that consideration, but putting yourself in the right mindset can be helpful long term. Okay. And then when we have these agreements in place, what do we do if something changes, right, in the middle of that relationship? Well, generally speaking, we might have an opportunity to amend or modify the agreement, but it largely depends on what's in the original agreement. So is there a provision covering amendments? Is there a provision covering modifications? Do we have opportunities to renegotiate? Or do we need to look at potentially terminating a relationship and looking at a new agreement? What we're seeing a lot in today's society, like now, is lots of franchisees out there, unfortunately, who are in their franchise systems and things aren't working out, or they're not getting what they expected from their franchisor, and now they want out. Franchise agreements are largely 10-year deals, and the franchisor has a lot of power and control. And so sometimes franchisees find themselves in this, haze of, what do I do? I'm in this ambiguous space where I want out of this relationship. It's not working out well, but now I'm stuck in this 10-year deal. Maybe I'm 3 years into it, 2 years into it. What do we do? How do we get out of it? Well, first and foremost, we look at what our negotiation strategies are. Can we negotiate something that's at some level collaborative, even if it's just, this isn't working out? Collaboratively speaking, the best thing for both parties is to just terminate and go our separate ways. What does that look like, right? So generally speaking, as advice to all of you, again, not legal advice, just friendly advice, negotiation strategies are more about it's you, it's me, but it's also us, right? So we think about a negotiation in terms of those three perspectives, and using empathy, we can say to ourselves, well, if I wouldn't take the deal that I'm offering, why should they? And we should find the best common ground to find a good, even playing field to try to work out a negotiation, right? To mediate a dispute if possible. That also works on the front end, right? When we're negotiating with vendors or with collaborators or with another entity or another independent that we might be going into business with. Again, thinking about, it's not all about me. They're also involved. There are human beings on both sides of these things, even if we're talking about entities. So how do we find an us solution to this prospective deal that works well for both parties? Think about aligning your goals and your intentions, and with the backup plan of some accountability if things don't work out, to build collaborative, what I call ROR, return on relationship. ROI is great. Return on investment's important. I'm not saying it's not, but another factor that we need to consider in our entrepreneurial endeavors is, how are we building relationships where we're bringing our value proposition to the table, working empathetically with other entrepreneurs to get back return on that relationship long term, okay? That's going to be worth a lot more than any ROI in sort of a small situation is going to be, okay? Organizations are run by human beings. Think about how you leave them feeling in any opportunity for collaboration. So we've been telling clients a lot lately that we are not a litigation-focused law firm, right? Our strategy is negotiation, collaboration, mediation. That's what we do. So you want to be open in your communication. You want to be transparent with other sides, especially if you're working on some version of collaboration, right? Whether that's partners that you're bringing into your organization, whether that's employees or subcontractors that you're going to be working with, whether that's vendors, even sometimes your competition. Good to be transparent, right? Remember, you're concerned about your future, but you can only help fortify those relationships through open communication, right? Think about the us as this separate consideration. The other side of that coin, of course, is being very cautious about what you're putting in writing and what you're getting in writing, okay? So if there's a dispute, if things are not working out well, if things are starting to get negative, be transparent, but be cautious and get things in writing, right? If you have a conversation on the phone with somebody, you're having a dispute that you're trying to solve, the next step after that call is over is to follow up with your notes from that call and say, just so we all understand, this is what happened on the call. These are our next action items. Please respond to this email and let me know if I got this wrong so that we make sure we all understand what's going on. Again, being effective in your communication is going to be directly proportionately aligned with your opportunities for success as an entrepreneur. Last but not least, if you're collecting any consumer data, which I know we all are, emails, names, phone numbers, or even more sensitive information than that, then the answer to that question is yes, you are collecting consumer data, and you might have some cybersecurity issues to consider. As the world continues to evolve, as AI is now kind of creeping into the way that we run our organizations and the tools that we use, you need to keep an eye on being really careful with customer data, being really careful with, again, your trade secret information, but also the sensitivity to cybersecurity liability and prospective issues. So kind of keep an eye on that. There's only so much you can do and only so much time you have in a day. So focus on those things to try to avoid and preempt any potential issues down the line, okay? The other thing to consider when you're looking at agreements, and this is just general agreement advice, is first and foremost, every agreement should have some level of a term, meaning how long is that agreement going to last, right? And think about the realistic completion or term of a project or collaboration. So if you're hiring an employee, there are considerations there, subcontractor, other considerations, vendors, probably a minimum of a year. Do you want automatic renewals? How do we get out of this agreement if we have automatic renewals? What's our exit strategy for leaving the collaboration or the agreement? Again, franchise agreements as an example, 10-year term. That's a long time. And so a lot of times if we haven't thought through our exit and we just sign things blindly, we're now handcuffed to this other party for 10 years. And if things don't work out in year 3, year 4, it's not going to be pleasant, right? Because you're not going to have a lot of outs. It's going to be more difficult. Same goes for any other type of agreement, not just franchise, your leases with your landlords, right? I know when we're excited about an entrepreneurial opportunity or a new venture or a business idea that's burning inside of us and that we can't wait to get out there. So we're, okay, just give me the lease, just give me that, let's get it done, let's get moving so I can generate revenue and bring my product or service to the world. Avoid making mistakes. Take a step back. It's great that you're excited emotionally, but do not enter these things lightly. I have seen scenarios where the landlord is as sweet as apple pie before they signed the agreement. And then they signed a lease. And if you didn't get those provisions in there to protect you, the landlord turns into an evil, kind of villain in your life story. And it's going to make your life stressful. I have one client, just a quick anecdote, had one client years ago that was signing a lease. Again, this landlord was the sweetest person on the planet. Oh, we'll do everything. We're going to put down new flooring. We're going to paint the walls any color you want. We're going to do whatever you want. We'd love to have your business. Luckily, they came to us. We negotiated some strategic provisions in there while everybody was happy and working on this agreement. Signed the agreement. The day this client is set to move in, half of the floor was not installed yet. We contact the landlord. We say to the landlord, hey, you said you were going to install the floor. What's going on here? Oh, yeah, we mismeasured. Mind you, this is the landlord's property. Don't know how you mismeasure your own property with a couple months of leeway to get that flooring in, but whatever. We mismeasured. We didn't get the floor in. Now it's back ordered, blah, blah, blah. This person called me crying, right? They have clients, it's Friday, they have clients coming in on Monday, they don't know what to do, they made this big business decision, they're hyperventilating, all of these things. We called the landlord, we said, excuse me, Mr. Landlord, you put in writing that you were going to have this flooring installed. We have a provision in that agreement that protects our client. They're not paying you rent until that floor is installed. Landlord said, ha, 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 I've never done X, Y, and Z. I'll call you back. Sent them an email, copy of the provision. That client did not pay rent until that floor was finished and being installed. A good lawyer will save you money in the long run, will save you stress. And again, you want to work with somebody that you can call and say, this person is not doing what they said they were going to do. What do we do? Right? Okay. So moving on from that, think through all of these prospective issues. Again, we want to be excited. We want to be happy with the decisions that we're making, but think through, what are my plan B, plan C, plan D, plan E, and as far down the line as we can realistically and reasonably plan for. Have your backup plans. That's going to put you in a position to be successful. Okay. Other issues, intellectual property. We've talked about this. Who owns it? What happens to it? Who is in control of it? Are there confidentiality provisions that we want in the agreement to protect the intellectual property that we're sharing? If you sign an NDA, this is a good opportunity to talk about this. An NDA is specific only to the terms in the NDA. Don't think that if you've signed an NDA with someone that all of a sudden you're covered forever. That's not the way it works. So an NDA covers a specific set of circumstances. If and when you sign some version of a collaboration agreement or joint venture agreement, partnership agreement, whatever it is, those terms may have now changed. So be very careful about confidentiality as you're transitioning from one agreement to the next. Okay, again, good lawyer, worth their weight in gold. Credit issues, who's going to be, on the hook for debts, who's going to be credited with coming up with certain things, right? If you discover something, if you invent something together, who gets what credit, is it shared, etc. Who is making what decisions and when, who is responsible for what, when, what accountability protections do we have in the agreement, and when are they triggered? Payments, collections of accounts receivable. I hate accounts receivable, okay? I want to know that we are secure in this deal. I want some money up front. I want that for my clients as well. I want to make sure that the process of collecting money is going to be as painless as possible. So if we can get, a good collections practice into that agreement and favorable to our client, that's going to be beneficial, right? So think about those things. How are we collecting the revenue? Can we get some of it up front? When are the payment milestones throughout the process, et cetera? Expenses, how are expenses related to the agreement covered? Who's covering them? What happens if they don't get paid? What's our plan B? Assignment provisions are related to whether or not, if we do an agreement together, can I assign that agreement to somebody else, effectively transferring my obligations to somebody else by sale or by any other form of transfer. So think about those things, right? You don't want to go into an agreement with somebody and then all of a sudden, 3 months down the line, they've sold their business to somebody else and you're stuck with that somebody else, okay? Or they've transferred it to their cousin who knows nothing about the business that you're involved in. And now you got a catastrophe on your hands. So think about these things. Liability and indemnity, who's liable for what and who has to watch out for who in what set of circumstances, right? So think about those things. And then if you have employees and you're working with another entity or another collaborator, are there joint employer issues? And again, that's something that can create some liability risks, something to discuss with an attorney. Thank you all for your time. I'm still going to stay and answer questions. Please go to Instagram at tlopes260. That's my personal account. It's mostly my dog's smoked meats and some pictures of my wife on occasion. At Lopes Law LLC on Instagram. We're trying to build that following and promote better content. Check out www.lopeslawllc.com. Lots of good stuff on the blog there. You can contact me through there as well, or 267-777-9117, or email me info@lopeslawllc.com. Okay, what other questions do we have?
The next question is, if you are fully remote, does the state that you file in matter?
Yes. So that, again, lots of tax questions on this webinar. It's a question more so for your accountant because that is going to be variable jurisdiction by jurisdiction. But yes, it does matter.
If you already file and use your home address, can you update to a virtual address?
Generally speaking, you'd have to file paperwork for a change of address. So there may be some fees associated. Again, it depends on the jurisdiction that we're talking about. Is it possible? Yes, but there may be some fees associated with it and forms that you need to fill out and file.
Is the master service agreement the same as operating agreement or acts as a contract for clients?
That's a contract for clients. So the operating agreement is related to the individuals that own the entity, the members of that entity. The master services agreement is to outward people, right? To clients or prospective customers that we're working with. So it's an agreement that you're going to lay out, maybe your proposals to that client, get them to sign and commit to that, committing to payment milestones, how revenue is going to be generated, those kinds of things.
If I have an LLC and work from home, my home address is the LLC registry and I'm sued, would my home be protected as part of my personal assets or would it be part of the assets for the LLC?
Well, that's a bit of a loaded question, right? Because you're operating a business from your home. So that's very variable, dependent on the set of circumstances. I would say that typically speaking, if possible, you don't want to use your home address for a variety of reasons. If there's a lot of liability risk associated with your business, then you probably do want to have a separate address for your business. Can you be sued for it? That's kind of a loaded question. That's case by case, and not something we can really address sort of generally. It would depend.
The next question is a two-part question. How long does this process of creating an entity typically take? And then the next part is, if you are opening a business in one location or state and providing services to people in other states, what implicates, if any?
Okay, so the process is variable depending on the state. I would say, ballpark around a month to get it done. Sometimes more, sometimes less. It depends on the state. And with respect to operating in different counties or different states, generally speaking, you may have some tax obligations. It goes state by state. You may have registration obligations. It goes state by state. You may have other licensing obligations that you may need to do. Anything that's related to operating in different states, all 50 states have a completely different and separate set of laws from each other. There are similarities, but every state is different. And then you have the federal government on top of everything else, right? So there's federal registration, and then there's state by state different laws in each of the states.
And while we're answering questions, I will be posting the quick 4-question survey. It is a requirement by our funders. That way we can continue to provide no-cost webinars to you like we did today. The next question is the attorney you work with to set up your business someone you should be thinking of having on a yearly retainer and work with for some years to come? If yes, would this be a typical retainer for a small LLC to think about on a yearly basis?
Yeah, I would recommend that if you can afford that. Keeping the relationship alive is always a good idea, especially if you really like the attorney. The more they get to know you and your business, the more effective they're going to be in helping you. Generally speaking, most attorneys, self-included, are going to charge you only when you're actually doing, some level of work, right? So keeping a retainer, even if it's a small retainer on so that you have an attorney to go to, is a great idea. Some law firms offer annual sort of, informal legal audits. We certainly do that. We also offer, monthly subscription to different businesses if they want that. You can always hire us a la carte. You can always, call or contact us, for example, or other attorneys should have similar setups that you can engage with. But yes, I would recommend considering having an attorney on retainer on an annual basis. That would be a great idea.
The next question is, how important is it to keep company money separate from personal money? Can you talk about the protective bill, please?
Yeah, it's absolutely critical. You want to avoid that as much commingling as much as possible. Separate accounts, separate bank accounts, absolutely critical. It's an important step in liability protection. It's an important step in the formality of running a business and the responsibility of paying your business obligations, your business taxes, and stuff like that. Even in a pass-through entity, you want to absolutely have a separate business checking account. There are great banks out there that offer no fee, business banking. I would highly recommend looking into that. Yeah, that's definitely something I would say you want to have as a separate business banking account.
If hiring a contractor through services like Fiverr, will you need an agreement?
It depends. Services like Fiverr sometimes have their own agreements. Look, I should also say that generally speaking, one of the conversations that we have with our clients when we're working with them on drafting an agreement is we look at the enforceability aspect of it, right? So practically speaking, it's definitely important to have things in an agreement so that we have, the legal structure and framework and protection in that agreement. But there's the practicality side of it of, is this enforceable, right? And what does enforceability look like? So depending on who you're hiring on Fiverr, there's that aspect to it, right? Does having an agreement really add a layer of enforceability for you or not? If there are intellectual property considerations, then definitely have your own agreement as an additional layer of protection, because that is something that's really difficult to protect and may not be adequately protected by whatever terms of service that Fiverr has. But or services like that, by the way, not just Fiverr. But generally speaking, you may not need it if you're hiring somebody to do a service for you that's going to be project based, and that Fiverr is going to handle all of the transaction, and frankly it's going to be one project and done. Then maybe you don't need an agreement in that instance. Kind of depends. But
Can you work with people hoping to create a business entity in another state?
so it depends, but generally speaking, yes. When it comes to business structuring or kind of counseling you on that sort of thing, as long as there are no specific state issues involved where we're not licensed, then that's fine. We work with, for example, franchisees or franchisors all over the country. We work nationally at that level. If it's trademarking or intellectual property, that would be largely federal most of the time. So we work with clients all over the country in that space as well. If there is a specific state, issue that we're looking at, we may or may not be able to help, depending on, again, whether or not we have an attorney that can cover that, et cetera. If we can't, we can often look at our network. We have a vast national network of collaborative attorneys that we work with. And so we would potentially connect you with one of them to get you the help that you need in another state if we can't help.
We have 5 more questions. Can you help businesses outside of Philadelphia, Northeast Pennsylvania specifically?
Yes, yeah, we work all over the state of Pennsylvania, so sure.
If you establish an EIN, sole proprietorship in 2022, use it to file your 2022 taxes, but for 2023 tax return, the IRS no longer accepts the number, should you be alarmed?
Maybe. I'm not, that's a set of circumstances that we could potentially look into for you. Reaching out to the IRS on your behalf to find out what's going on and maybe correct that EIN issue.
I have some detailed questions about my business and I am based closer to Pittsburgh. Is it better to find an attorney closer to home?
Not necessarily. So again, we work with clients nationally. So we're able to handle, we certainly can work with somebody in Pittsburgh, I think. But give us a call or shoot me an email and we'll take a quick look at your specific scenario. And if we can't help, we'll certainly be transparent with you and tell you that you should look for a local attorney. Most likely we can help you with anything that you need help with.
This question is targeted towards nonprofit organizations. If you're able to answer, which person should file a 501c form or a 31023 form from an attorney or accountant?
Yeah. Contact us. We can help with that certainly, but reach out to me directly so that either by email or again call or reach out to us so that we can help you with that. It's going to be specific to your specific nonprofit, and so we want to make sure that we do that correctly.
And the last question is, if you are fully remote and have clients all over the country, does the formation state have to be the same as the sole member's current living address?
Sorry, one more time.
If you're fully remote and have clients all over the country, does the formation state have to be the same as the sole member's current living address?
Again, that's more of a determination based on your specific set of circumstances and what's most convenient for you from an administrative perspective. So it kind of depends. And also, looking at whether or not administratively it's going to be a big burden to have it in a different state or to have it in your home state would depend.
Okay, that concludes all the questions. A follow-up, will be provided with Tony's slide deck as well as the recording for this presentation, as well as the contact information for Tony. If you have any questions, please feel free to reach out. Thank you everyone for joining us, and thank you, Tony, for presenting.
Thank you, everyone. Have a great day.